recognizable. Now we take the question answer. Please be seated.
Hello, I'm Zina Chagani, and just want to ask you. Can you hear me? Can you hear me? Can you hear me?
See, you can ask in Hindi, Sindhi, Punjabi, Gujarati, any language. I'll try to answer.
Now I'm okay with English. I'm Zina Chagani.
नहीं हिंदी में भी अच्छा लगेगा क्यों नहीं नरेंद्र मोदी बोलते हैं ज़्यादा हिंदी में anything whatever convenient
मेरा एक छोटा क्वेश्चन है. Suppose a will is made in 2006 and there's a codicil. Some
Friends, one second. Please stop the tea and coffee, please. We'll continue after some time.
And somebody wants to make a codicil to the will. It's been
फिर से बोलिए
registered.
ना प्लीज
A will has been made in 2006 and someone wants to make, means the person who's made the will, now the person is very old, they want to make a codicil to the will.
codicil he wants to make
Codicil to the will.
हाँ.
The will is already registered. So will the codicil again have to be registered?
See, there was what you are asking the question, this was the view of some of the high courts, but then later on it was held by Supreme Court. It is not necessary that the codicil should also be registered. Even ordinary codicil executed properly, just like a will, in the presence of two attesting witnesses will be valid.
That means what you're trying to say.
It is not necessary to register it, simple.
Okay. Means what you're trying to say that the will stands good. Only thing in addition to that a para can be added with two witnesses.
See, the codicil, there are two ways of writing it, amending it. Either you make a new will totally.
No.
Or you make, as I said in the beginning, you make a codicil.
Yeah.
And it is not necessary to register the codicil. If you want to register, you can register it.
No, but without registration also will it hold good in court?
Why not? It's perfectly valid if you are having a attestation properly done. So it will be valid, no?
Attestation means notarized, that's what you're saying?
See, as I said, precaution means have two wills, notarization if you want, have one notary if he can attest you.
Yes.
Why not one notary, one dog? It is, first of all, it is not necessary there should be only two witnesses.
Okay.
You can have four witnesses also.
Okay.
Two witnesses, third notary, fourth doctor, why not? Nothing wrong.
Okay. Okay. And it doesn't alter the first will at all. And it's just an addition to the will. That's all I'm trying to say.
That's all simple. It is not necessary. If your will is registered, it is not necessary that codicil should also be registered.
Because what I feel that codicil become much easier than making a gift deed. That's
fine, fine. I think whatever is convenient to you.
Thank you.
Madam, please pass the mic to the second person. Yeah.
There is one question. Thank you. Mr. Ramani sir, towards the end you mentioned something about an HUF.
Yes.
So I have a peculiar problem regarding HUFs. My father had his own HUF which had its own shareholding, and I have my HUF which again has its own shareholding. Now, once he passed away, I presumed that, because I have become the Karta of the HUF, I presumed that I will just become the signatory in my father's. They'll substitute my name as the Karta. But apparently that is not possible. And that has created a great complication for me. What they're saying is, I need to open another HUF. I said, I already have my own HUF account. I already
That will is different. This HUF building is different. That is HUF different.
Sorry?
You may have one HUF for you, your wife and children.
Yeah.
Another HUF of your father, where you and your brothers, etc. are also there.
Correct.
Both are two different.
Correct.
And the eldest son normally becomes the Karta of
Correct.
HUF.
Correct.
So you can be in two Karta of two different HUF.
Two different HUFs.
One with your children, one with your brothers.
But the second HUF continues as in his name,
what happens?
as with the father's name?
See, I tell you now, it's a big history. Earlier, prior to passing of Hindu Succession Act 1956, if there was a HUF was consisting of only male co-partners, mard. So after in 1956, when Hindu Succession Act was passed, they said now Karta's wife will also be entitled, and the share of a person who's dying, deceased person, they will be deemed to have died. On that day, there will be presumed to be partial partition of that HUF, and his share of the deceased after 56 will go to his legal heirs as per schedule Hindu Succession Act. Means now after 56 that position changed. Now in 2005 another position change, even daughters will become total. That's the only thing. Now if your partition had not taken place before 20th December 2004, your sisters can also claim share. That we'll have to examine the whole history. It's not easy.
No, my point is I'm an only son. I'm an only child actually. Only child.
Your fathers, you are the only son, you don't have brother.
Only child.
Acha.
So, then, what I said is, make me like for a corporate entity. The signatory has changed.
You are,
earlier
also you were karta of both the HUFs, no?
No, I was not. My father was the karta of his HUF.
And after that you have become the senior most.
Yes,
then,
yes. So, but that is a difficulty. They cannot make me. They say you have to have HUF in your name.
This needs to be examined, your whole history. You'll have to see family history. It's not that easy.
Okay. Thank you, friend. Next, Mr. Basu. Either.
Singh साहब बोली, Singh साहब बोली. हाँ ठीक है.
Shall I just have a quick question. Thank you so much for enlightening. Basically, just I'm asking a question. You spoke about somebody doesn't write a will. It follows the Indian Succession Act. Now, what does it say? I mean, let's say this person has got 2 sons and 1 daughter. Will it be, the property will be distributed equally, or is there any law? I mean, these are the things.
No. See that there are, as I said, that there is a, if somebody dies, leaving behind mother, wife, son, daughter, it will go to mother, daughter, son equally. And if one of the sons is died, then the children of that predeceased son will also get the share of the father. So that is the schedule. Many people don't understand. Now, supposing son dies and mother is alive, there are so many cases, mother-in-law and daughter-in-law. So that mother gets a share of the son equally. Mother, son, daughter, wife, they all get equally. If Hindu, I'm presuming Hindu.
Sure.
Under the Muslim law, there are different provisions.
There's one more question. Can somebody disown, I mean, in his will, write that my son will not get anything, but his son will get? There was a case long back.
No, I tell you now. See, if it is your HUF property.
No, it's normal.
If it is HUF property, your son gets the right in HUF. If your self-acquired property, you can make a will in favor of anybody, maybe stranger. Why son? You can give to any outsider. Priyambada Birla, I told you the case. Loda. She gave it to Loda, who are not related to her. She is a Hindu, she was a Jain. He was a chartered accountant. So that was held as upheld. There is nothing wrong.
No, that
he can disown his son. There is no question.
No, there was the reason I am asking this question is there was a case where this person didn't give it to his son, for his grandson, and after he passed away, the grandson gave it back to his father. Now that was not the intention of his, grandfather.
So you can't stop somebody. I give it to my grandson. If he gives to anybody, how can I stop that?
But then originally you are challenging the original will of the.
No. See that once I give the property to you, it is you are the owner. You can deal with as you like. I can't have control unless, in this case, I can make a trust under the will. That's again a big discussion.
Okay.
I can make a trust under the will that I appoint A and B as a trustee. The income will go to the child only for 18 years, and after it's like that, other things can be made.
Thank you so much.
Mr. Basu, one question per person. Yes. Just pass on the mic, please.
बोलो सिंग करे करो.
रमानी साहब, you know my name.
आप अपना नाम बताइए.
मेरा नाम APN सिंह है. I've got one daughter, and I got agricultural land in UP, and I've registered the will. Now the will is not a specific will. It is written कि all my agricultural land will be bequeathed to my only daughter. Now there is also property which is locked in litigations for the last 67 years. So assuming when I get my share, if I'm alive,
I understood. I'll tell you one.
Will she get it?
No, I'll tell you one thing. So there are 2-3 ways of tackling this problem. it is not necessary that you should have only one will. You can have separate will for each of your properties. You have made one will for your agricultural land.
No, my question is...
No, I'm giving you, please hear me. You can make another will that I am having litigation of this land. Whenever this decree is passed in my favor or my interest is created, that interest will go to so and so. You can make another only one. See,
provisional will.
For each will, each property legally you can make separate will for each of your properties. And the properties under litigation, you can make a separate will.
No, but what is advisable? Abhi, whatever is in my possession, I've made that will. Okay, that's clear.
I think what you should do, simple, all the properties, whatsoever and wheresoever situate at the time of my birth, in which I may be entitled to my daughters absolutely forever. Your will is over.
Okay.
Thank you, friends. Please be specific, please.
Hi, just wanted to ask, you mentioned executors in the will. So can they also be the beneficiaries?
Registration, as I told you, did not
Not
come.
registration. Executors of the will, can they also be the beneficiary?
Yes, absolutely.
No problem on that.
As I told you, if executor
Yeah.
refuses to act as an executor as I did, then that executor loses the bequest in his favor. Otherwise, there is no harm. A person can be beneficiary, Hindu I am talking about, Hindu can be beneficiary, executor and witness.
Okay. Perfect. Thank you.
Chalo,
But
next.
Christian, we have to be a little more careful. The laws are...
Sir, a will was made in 2012 from my mother-in-law. It was registered as, but you said the probate is very necessary.
Problem?
Probate.
Not, absolutely not. See that if supposing you are having your father left a will, grandfather left a will, it's coming to the legal heirs. If you want to sell the property, all the legal heirs, if they join together, there is no need of probate. It depends.
So, if suppose it has to be probated now, can it be done?
See, probate can be obtained after 20 years of the will also.
Okay.
Nobody prevents you.
Thank you.
And will can be registered even after the death of the person.
Okay, thank you.
Is there any cost to probate? Is there any cost to probate? See, maximum probate fees is 75,000 rupees. And then advocate's fees, depending on which advocate you choose.
Sir, the registration of the will is not necessary as my advocate said.
It's advisable. If you are little doubt about your succession, better to have the will registered.
And there was a case, suppose the flat is in the name of the two persons, first and second, and then nominee. And the will made, in the will it is made, it is given the flat to the other person. What will be the situation then?
No.
In the
A
will.
and B are owning the flat.
Yeah.
A is bequeathing the flat to B.
Yeah. See, it's
Joint owner, isn't it?
joint owner, okay?
Nothing wrong. Very good.
Then, but the will says that it is to be given to the third person. Then,
The will prevail. Nomination will not prevail, as I said, in the cooperative society.
Okay.
If the flat is owned through the medium of cooperative society, nomination can be made, but the nominee is not the owner. The will is the owner. Once you take a probate, the person who is beneficiary under the will get the flat and not the nominee.
but the second owner,
His, again, second owner, whether he had contributed equally or whether, see, I tell you now.
he has not contributed. Just
I tell
take
you
a
one
second,
thing.
husband wife.
I tell you now, I'll give you one example. Husband and wife, husband is earning, wife is housewife. She doesn't earn anything at all. She's not filing income tax return. They are buying a flat of 5 crores. Entire amount is paid by the husband, 5 crores. Wife has not paid anything. But for the sake of emotional value, husband says, no, add the name of my wife. The flat is owned by husband and wife. So husband, in income tax and wealth record, husband is the owner. Although she is associate member in the society. So in this case, husband will continue to be the owner of 100% right. Although her name is there. So in this case, better to make a nomination and will in favor of wife. take another case. Two brothers are staying together. They are buying a flat jointly. They are buying a flat of 6 crores, 3 crores, one brother, 3 crores, another brother. So they decide elder brother's name should come first. So in this case, when both will be treated as equally, because circumstantial evidence, their income tax wealth record will show the second holder was also the owner. In the first case, wife was associate member, was not the owner. But when the two brothers are buying, showing their equal contribution, the second brother is also the owner. So you have to study, there can't be general rule, the associate member is not the owner or owner. So we have to see the circumstances, evidence.
Yes, madam. Go ahead.
Good morning, Ramani sir.
One second.
Hanji.
A will was made by my mother. After
I am surprised nobody is asking question in Hindi here.
अच्छा ठीक है, मैं हिंदी में पूछती हूँ.
हाँ पूछिए.
Will बना हुआ था. उसके डेथ के बाद, in the will, daddy was the executor and the beneficiary also. Okay, he has also passed away.
Whose will?
Mummy's will.
Your mother's will, and your father was executor and beneficiary. Okay, fine.
Okay. All the other legal heirs are also mentioned in the will. That is his children, grandchildren as well. My question to you is, since mummy की will थी and daddy भी अभी नहीं हैं, उनको 7 साल से ऊपर हो गए मम्मी के डेथ को. Okay.
7 years. हाँ.
Over 7 years, actually 10. कितने टाइम तक will contest हो सकती है after the person's will?
No, will can be contested any time. There is no time limit.
Is there a 7-year time limit?
No limitation act. As I said, because you can always take, there is no limit for getting, normally there is a limitation.
Yeah.
As far as the will is concerned, will can be probated even after 10 years.
No, I'm not talking about probate. Probate nahi.
Once the
Contested.
Once the probate is taken,
Yeah.
the person mentioned in the will become the owner.
Okay.
There is a that's what I'm saying.
Okay. So अभी जो भी will
In
में
many cases,
mention,
normally there is a limitation act, but in this case, there is a special concession given for the will. You can register the will after 20 years. Supposing my father had made a will, he dies 20 years ago, I can go and register it even after his death.
नहीं वो
Second, the will, somebody died 20 years ago, brothers were living happily, very, very well. Now there is a dispute. So one brother in whose favor the will was made, now he goes for probate. If he gets the probate, he succeeds. High Court will decide, see in case of dispute, if your brother has got a will and you feel the will is not genuine, you can file a caveat in the High Court.
Okay.
Once the caveat is filed, the probate application is converted into suit.
Okay.
There is a hearing. After the hearing, if the matter is decided in your favor, the person who gets the probate, he is beneficiary, that will prevail.
Okay.
I think hope make it clear.
Yeah, that is clear. That is one
Another, I
aspect.
think she also wants to ask.
Will is also registered.
आप बाद में बात.
Okay.
Oh, I think. आप बोलिए ना प्लीज लास्ट. वो गाड़ी चला करवा दी. बस हट बस
Good afternoon, sir. Good afternoon.
Yes, madam. Go ahead.
Yeah, I have a question. If I make a will,
Can't hear you. Put your mic up little. Yeah.
good afternoon. My name is Shalini. I want to ask you, if I make a will, I have 2 kids who are minors, and in between now and till they become majors, that is 18, I presume 18 or 21. My children are young, so if I have 2 daughters.
See, if you are making, as I understand, if you want to make the will for the benefit of your minor children, it's always advisable to appoint guardian, or you can create a trust, as I said earlier, in the will itself. There will be no stamp duty. You can create a trust appointing A, B, C as the trustees, or you can appoint, give my bequest this property to my minor daughter till she becomes 18, so and so will become guardian. That can be done.
And the expenses and the accounts will be looked after by the trust.
Whatever you want, in such cases, better to make a trust under the will, which is little troublesome, but it serves the purpose. Whenever you have seen minor children are there, one can always create a trust under the will. And you can have a trustee separately. Executor can be separate, trustees can be separate, but that's a matter of, again, big discussion.
And is the executor the trustee?
Yeah, madam, can you be brief, please? Yeah. The last question, Mr. Pankaj. Yeah, mic, please. Yeah, madam, just take the mic.
Hello. Suppose there's a family agreement which is not registered.
Please.
Just tilt the mic, madam.
Suppose there's a family agreement regarding the distribution of share in the property which is not registered. And any of the part owners of that property dies without making a will, does the property go to the remaining two co-holders, or does it go proportionately to the person who has died without making a will to his children as well?
It's the most complicated question you are asking, the last question. You know, there are judgments which says recording of family settlement need not be registered. And see, if you are making a family settlement today between you and your brothers, you have to pay stamp duty on that. But if you are recording an event which has taken place in the past, that such an event only, this is a memorandum of recording, can be on 100 rupees stamp paper, nominal. But problem arises, if you go to register this family settlement, the registrar will say there are partitions. You and your brother has got one flat, you and your sister got another flat. So each case they will presume partition and then they will register it. So unless there is a registered document, things become really difficult. Your case is quite complicated. It's not easy. Because law is one thing, and then these registrars they refuse to register. And this is, in case of immovable property, Section 17 of Registration Act says, any transfer of immovable property must be by registered instrument. So I think you'll have to sit. Sometimes it's not easy.
Friends, I myself, Prem Asrani, Managing Committee members, on behalf of Ashok Bonani and Khar Gymkhana, thank each one of you coming this morning and listening patiently. I request all of you to give a standing ovation to our KK Ramani. Thank you, friends.